Welcome. Today's session, we're reviewing the state of Texas along with the state of California regarding the child support process. Why the state of Texas and California? Well, those are two most populous states in the union, as well as Texas, as you know, generated the most revenue from the garnishment and income withholding. Let's get started. Hello, my name is Chris. On today's session, we'll review and compare the state of Texas with the state of California and look at how they monitor, administered the child support program and how those rights are in conflict with your rights. As we've said, our non-lawyer maxim, which is we can provide suggestions and comments regarding the law without being charged with whether we're administering the law. And as we've said in Scherer versus Board of Education, the practice of law cannot be licensed by any state. So on the screen, we're going to start off with the overall financials of the program. On the screen, it has the total CSC child support collections is $28.5 billion. Within that same fiscal year, the program, child support program, paid out $27.4 billion. So if you do the quick math, 28.5 and you subtract 27.4, there's $1 billion difference there. We receive these numbers because, as you know, any program that reports in the Congress is required under the Budget Office to provide their financials. The Title 40 program is part of what we call a single and separate unit, 45 CFR 301.1. So let's start with the state of Texas. It says here the Department of Health and Services is responsible for the child support program. However, under the state of Texas, they're claiming that the Office of Child Support is part of the Attorney General's office. Again, that's not according to statute. Under California laws, the single and separate unit is found under the Secretary of Health and Human Services, which is correct. On the screen, I have a copy of the strategic plan for 2015 to 2019 for the California child support program. And where it is, the director of the California program is Ms. Alicia Griffins. So they're following the guidelines. We produced 2 other videos on this channel for the state of Texas, and we suggest that you look at those videos as well to get the details on Texas as we move forward and compare it against California. Whether or not you live in Texas, it's okay. It doesn't hurt and it doesn't affect anything if you just review the state of Texas and their program. Also, we are working on research to produce the California video regarding the financials. And what we're asking for you to subscribe and hit the notification bell when we complete that video. We'll send you a notice. So let's review the child support enforcement program. It's in all 50 states, and the federal government reimburses each state 66% of the cost of operating the program. That is, for every $2 collected by the agency, $1 is the federal government is responsible for sending as what's called reimbursement. Also, anyone in the states or officials who's administering the federally funded program, the state officials, those same officials, are operating under the color of law. And the case law is Tongle versus Usury. We have a video on this site called Know Your Rights. We suggest that you review that video. And if you've done so in the past, review it again. There may be some tips and strategies there as well. We have a section called Call to Action at the end of this video. And what we do is, for that section, we raise the questions here, and then we follow up with some of our suggestions of how you can use that to remedy your situation under child support program. So here's one of those questions. If the Office of Child Support is designated by Congress to be part of the Health and Human Services, how is it that Texas is the Title 4D program? So the question becomes, who's the boss? Because the Office of Attorney General actually reports to the governor's office. So when they administer the program, that the Attorney General moves 1, 2 levels down to report directly to the secretary. And it says here under 42 U.S. Code 652 that the secretary, that the person who operates the Child Support D program, shall report directly to the secretary. Well, that's a jurisdiction on the constitutional question. You should be screaming. So here's an additional information. Whether you download a template or buy a template for someone, or someone gives you a template, this question must be answered in your paperwork, because this is an opportunity that you're overlooking. You're overlooking a jurisdictional challenge if you don't include that in your paperwork. Challenge jurisdiction at any time. As we've said, if an officer violates your constitutional rights or your rights under any program, that official is stripped of their official character and can be sued in federal court. See Pennhurst versus Halderman. So the Attorney General office and those attorneys operating the Child Support D program, basically, as this says, they can be stripped of their official responsibility. In other words, they're moonlighting as attorneys, and they probably calling themselves attorney generals, which they're not. And we'll look into that further. So let's start off with the 2010 Census Bureau, right? So for the state of Texas, they have 28.7 million. That's their population. And for California, is 39.6 million. So California is about 10 million greater than Texas in terms of the number of people within the state. And here are the numbers as prepared for Congress and the committees regarding the child support program. And that statute is called wage garnishment or income withholding, and that's 45 CFR 32. As you can see, it's $39 billion for the state of Texas, right? California, as we've said, generates or collects 2.4 billion, okay, for 2018. So we call that unbalanced. So let's quickly review the administrative wage garnishment, which is 45 CFR 32. And on the screen, it says, here's a possible remedy. And that remedy is that the income withholding order that is sent to your employer is really what is called a creditor agency. So that means the Title 4D is nothing more than a creditor agency under the program. It is not a judicial function. So we put here on the case laws, which is Sage versus United States. And the Supreme Court agrees. It says that the child support agreements are equivalent to interstate contracts and rejects the idea that somehow child support obligation is something different. You know, it's a court order. No, it's not. It is a regular contract like any other contract under the Constitution of Congress, or the responsibility of Congress. So now let's look at what is called the arrears, or projection of arrears for 2018 for Texas and California. So Texas is coming in 16.9, close to $17 billion of what they call projected arrears. California is 17.5. So there's a little bit of difference between the two. But here's the thing. We know that child support and arrears are imputed based on what they call earning capacity, not necessarily based on your income. So basically, they make up the numbers. So these projected arrears, you can't really trust them because the numbers were made up. And the case law for that is Kessler versus Kessler. Interest on arrears. Every state under 45 CFR 304.5, they charge interest on arrears. So it says here, states have the authority to charge interest on unpaid support payments and arrears based on state statute. So example, if Texas is 10% and California is 15%, those are the interests that are charged on imputed or fictitious arrears. 45 CFR 264.30. We have said on this channel that every man in the states, in the US, are all enrolled in the child support program. It's just that some men do not have an active case. So this leads us to what is called paternity establishment for 2018. Texas had 157,000 about paternity acknowledgement. While the state of Texas, in the state of California, they have 164,000 paternity acknowledgement. Paternity acknowledgement are basically where you sign the acknowledgement of paternity form, and that's usually done in the hospital, and it's among all the paperwork that you sign, including the birth certificate. The interesting thing is that this is one of the jurisdictional requirements in order to be enrolled in the child support program, which is acknowledgement of paternity. We have a video on this channel that talks more details about paternity acknowledgement. So this brings us to case law called Blessing versus Freestone. Even though you've signed the acknowledgement of paternity, the Ninth Circuit came back and says, when they looked at the Title 4D program, they said, wait a minute, there is no federal right to the program. The Title 4D was not intended to benefit the individual child or the custodial parents, and therefore there is no rights, whether it benefits them or not. So a paternity establishment is what? An agreement, but that agreement does not establish as a right to the program, as in here, Blessing versus Freestone. So let's take a look at call to action, right? Texas versus California. We suggest that you get a copy of the Department of Justice letter and the COL form. Also, ask for the Attorney General contract or agreement, being that they are involved in the child support program, not from a legislative perspective or what we call under judicial law, it's under contract. And then most importantly, here's your remedy. One of your remedy is motion to dismiss your case to escape your case. Yes, most of the time people put in paperwork and says challenge jurisdiction and they're talking about subject matter, but they're not specific enough. We feel that one of the dismissal challenges is failure to join the indispensable party. Well, we now know that the Attorney General is not one of the indispensable parties under Texas. They're a contractor. How did they get into this case? So therefore, this is a remedy for you to do a motion to dismiss, to get yourself out of the case, because this mess between who has control and who reports into whom, you don't want to be a part of that. Now, if you disagree with any of our suggestions or a review of Texas and California, please send us an email. We'll entertain your questions. In addition, we ask that you subscribe to our channel, as well as hit the notification bell to be notified of new videos that we're working on. Also, we humbly ask for a donation of approximately $25 as a gift or any amount thereof to help us continue our research. Yes, you could review or find many of this information on the internet. It would probably take you a few hours to find the right cases. What we've done is, and again, this is our opinion, we've selected a few laws that you could use. You just sit down with your own cup of coffee and review what we've presented to reduce your research. So this brings us to our end, where we compared Texas to California. There's a few other videos that we recommended on this page here. Please feel free to review those. And thanks.